Welcome to today's episode. We are diving into one of the most technically demanding and globally important areas of dispute resolution, which is construction arbitration. As projects grow in scale and complexity today, from metros and motorways to data centers and energy infrastructure, the disputes around them are becoming equally sophisticated. Arbitration has undoubtedly become the forum of choice, but it raises its own questions. Is it keeping pace? Is it becoming more efficient or more complex? To unpack all of this, I'm honored to be joined by Mr. Samuel Townend, King's Counsel, one of the leading construction silks at Keating Chambers, London. Mr. Townend has acted in some of the most significant construction, engineering, and energy disputes internationally. His experience before tribunals across the world gives him a unique vantage point on where construction arbitration is today and where it's headed. He has been the immediate past chair of Bar of England and Wales. Samuel is an enormously respected silk with heavy practice across the spread of Chambers' work, be it domestic and international. Most importantly, we are privileged to welcome him. He's known as to be a first-class advocate with the tenacity of a pit bull and manners of an English gentleman. I have had the opportunity to personally watch him speak for a 2-day course in construction arbitration in India in September this year. And I'm very honored that he agreed to my request to feature it on this podcast. So to just dive in through the conversation, I would like to give a brief of what we are going to cover in this podcast. We are going to explore what truly sets construction arbitration apart, what are the changing nature of disputes and the rise of technical claims which are being made in the construction arbitration, what is the innovation in the procedure and evidence, how experts and technology are reshaping the process. We'll also look ahead what skills young lawyers need and how cross-jurisdictional practice is evolving and what the next decade might bring for the construction arbitration system. So, very warm welcome, Mr. Townend, to
Thank
our
you very much,
podcast.
Nidhi. A real pleasure to be here with you and your viewers and listeners.
To set the stage, Mr. Townend, how do you see the current state of construction arbitration globally? Do you see it as it becoming more complex or more efficient?
Thank you. Well, certainly it's in a state of growth at the moment. The state, therefore, of construction arbitration globally is a healthy one. We see across the world new arbitration institutions specializing in commercial generally, but also including construction arbitration being set up, whether that's in the Gulf, in particular Saudi Arabia at the moment. In India, of course, as you well know, the opening of a number of international institutions associated with particular cities. We see the healthy numbers of construction arbitrations referred to institutions in Singapore, Paris, and London. So it is growing. It is more complex. Perhaps we'll come on to some of the reasons why, but associated in particular with the profusion of documents and information. And as for efficiency, I think there are efficient measures being put in place. There's provisions for having truncated procedures, and we'll no doubt go into some of that. The different aspects of it is part of our discussion, but it's in a healthy state, and so it's good for your. It's an interesting area for your viewers and listeners to consider going into.
Thank you so much, Mr. Townend. Having said that, what distinguishes if we go into more detail, a more detailed aspect of it, what distinguishes construction arbitration from other forms of commercial arbitration, especially in terms of claims, evidence, and procedure?
Yeah, of course. There's a whole host of differences, and you and I spent 2.5 days discussing some of those differences in the course that you referred to. Obviously, the starting point is the different subject matter. It's very particular construction. The subject matter includes typically issues of delay, heavy on financial matters, quantum. The nature of those claims is they involve heavy expert evidence, and also of all types of arbitration. Construction arbitration is probably the heaviest in terms of documentation and information. And so we see the development of IT tools. AI is certainly playing a role and going to continue to play a role. But then there's also some thematic issues. So when it comes to residential accommodation, for example, you've got challenges associated with fire safety. So those are some areas. So heavy on documentation, paper and electronic, heavy on factual content, almost invariably requiring expert evidence, often in multiple disciplines. And it's really not suited to a generalist court, but eminently suitable for the interested and experienced tribunal.
How do you see that, that if you look at the changing nature of construction disputes today, in your experience, what are the most common causes of large-scale construction disputes today, especially with respect to the design failures, the delay events, for example, the ESG obligation or contractual risk allocations?
Yeah. Certainly I see a bit of a distinction between the international and domestic position. International arbitrations are very much focused, construction arbitrations are very much focused on, I think, delay, on variations and money, and quite often on termination, how these contracts come to an end. Whereas domestic arbitrations, and this may well be true in India as well as the UK, there's more on defects and the sort of the more technical specialist parts, perhaps, of cases. So that's where I see the distinction. So not so much, as you mentioned, design failures in international construction arbitration, much more on delay. I can't remember the last time I came across an international arbitration where delay wasn't a significant feature. Of course, contractual risk allocation is right at the heart of it, and very often there are issues about, for example, who carries the risk of the delay, what notice requirements there are if you wish to claim an extension of time as a contractor, or damages arising, compensation arising from that delay, and conversely, what are the requirements for an employer when seeking to levy liquidated damages. So those are the sort of common causes of the disputes. I also see in the international context, quite often there's some sort of state entity involved, often an agency, whether this is true for South Asia, it's true for the Gulf, and it's true for Europe. There will be a large infrastructure project that is stewarded by the employer, is a state entity. That creates its own complexities in terms of how does each of the parties behave, how do they make decisions towards settlement or not. why do we end up in an arbitration? And quite often there's the decision-making process for a state entity is quite different to that of an individual, a high net worth individual, which is also different to a fully private company who have to account to shareholders, but who are very much focused on the financial bottom line, not on, if you like, fault finding or responsibility. So those lie behind why disputes end up in full-scale arbitration, and that's a particular feature in relation to development projects or infrastructure projects.
It's very interesting what you pointed out, and if we move on from the aspects of delay that you highlighted, and overall, if we take a larger picture, a larger view on this, how do you see that the value of arbitration compared to litigation, especially in construction arbitration? Your thoughts on this, sir?
Well, I think it is very valuable in both our home jurisdictions. We have a court system that is in significant delay. The priority, certainly in the UK, is towards processing criminal cases. And so we have backlogs of cases. And in relation to construction matters, of course, they are complex and can be difficult. So arbitration allows for the agreed appointment of a neutral specialist tribunal, so at a neutral venue. So the parties can therefore tailor who is to resolve their dispute for them, which is a real advantage. Secondly, the procedure is private and confidential. There is no washing of dirty laundry in public, to use that phrase. And that can be important if there is commercial, political, or other risks associated, or potential embarrassment associated with a case. Thirdly, it allows for flexibility of procedure. There's a whole host of standard sets of rules and processes which can be adopted, but you can also, by agreement or by direction of your tribunal, have a bespoke procedure that's tailored to the needs of the particular dispute. And it can be, and it usually is, more speedy than a court-based process. So, to give you an example, FIDIC engineering contracts, the international engineering contract that is used often in cases, for example, infrastructure projects in India that involve an international contractor. They're one of the standard form contracts. They provide, as part of a dispute resolution mechanism, a short form dispute resolution process called dispute boards. And that provides a speedy process, allowing for a determination within somewhere between 3 and 6 months, perhaps a bit longer if it's more complex, from commencement. That may be in advance of litigation or arbitration, but it's a quick process that allows the parties some degree of certainty as to likelihood of outcome, particularly if you have a dispute board, as they call it, a tribunal that is respected and has spent adequate time on it. So arbitration is flexible. It's in the hands of the parties as much of in the hands of the tribunal. The tribunal will tend to want to head towards a final determination on the merits as soon as is possible. So there is less, in my experience, procedural wrangling and applications. Of course, they are necessary in some cases, but it allows a thorough examination of the merits of a case by a specialist tribunal. So that could be, say, an English KC, an Indian senior advocate that specializes in some construction law, retired judges perhaps, or a mixed tribunal including, say, a quantity surveyor or an engineer alongside a legal specialist. And it also avoids the delays and inefficiencies of a generalist court system. So those are the many reasons why arbitration has its advantages over our court system.
That's a very very detailed and a very fine understanding of what you've given us, Sam. I would want to a little bit narrow down a little further for our listeners, where I would like to hear your views on the procedure, efficiency, and the innovation aspects of construction arbitration. So, construction cases, and like you also mentioned, involves massive amount of technical evidence.
Yeah.
What procedural innovations, such as commonly referred to as hot tubbing, early neutral evaluation, or document light arbitration, are proving most effective as per your experience, because you are so active in this field both domestically and internationally, and doing so exceedingly well?
That's kind. Taking those three, the overall picture, yes, there are innovations in arbitration, and that's one of its advantages. It's easier to bring in new processes, new techniques into arbitration than in court. Hot tubbing, in fact, or the taking of concurrent expert evidence, to give it its fuller name, is not so much a new innovation these days. It is frequently used in my experience, and it's where you put the two experts together to answer questions in series. So instead of just having orthodox cross-examination, you actually have the two experts together engaging in a form of debate. So they're in together, which is why they're in the hot tub. I think that can succeed or fail depending on how it's set up. As a trial advocate, my preference is very much to have counsel cross-examining the experts first, and then for the experts to go into the hot tub to answer questions from the tribunal and the counsel direct, but together. Early neutral evaluation. In fact, my experience is that that's really a sort of outside the remit of arbitration. That there is provision for this in the English court system, that you can have a pause in the process to conclusion to a final hearing and ask a senior lawyer or somebody else to give a neutral opinion, a neutral evaluation, but without it being binding on the parties. It's used, but not very often in my experience. Document light arbitrations absolutely are quite possible. We have some domestic rules in the UK called the CMAR rules, which provide for a shortened process, tends to be for less complex, perhaps lower value cases. I note that, for example, the IAC in India has also provided for that sort of shorter form of arbitration. We'll have to see how it's going. I would say, though, there are three other innovations which are really important in this field. First is active case management. That allows the tribunal to really take the initiative in cutting to the chase, in focusing on the issues which they can see are really going to determine the matters. And it's very often, for example, that at the first case management hearing, your tribunal will issue pages, even as many as 90 separate orders in terms of case management to the final hearing. So active case management, a presider of the tribunal really being on top of the case, is a really good innovation, because of course you're not going to get a different judge, you're going to have the same tribunal at the end. It helps everyone. It's efficient if your tribunal is well on top of what is happening in a case. Secondly, mediation. I'd say mediation, more than early neutral evaluation, is a very useful extra arbitration process. If the parties have set out their cases and they know roughly where each other stands, and they have the ability to settle, which, as I say, certain parties find it easier for a third party to determine the case than they are themselves willing to compromise. But if in the right case with the right parties, a one-day, say, mediation between two commercial parties can really cut through matters and can achieve a settlement. And thirdly, the allocation of party costs. In the English court system, you are at risk in the courts in relation to party costs, the costs you incur in preparation to trial. In many jurisdictions, in practical terms, India's one of those, you don't have the ability to award party, or you tend not to, as a practical matter, award party costs. So the successful party does not tend to get their legal costs of pursuing the case to a final determination from the unsuccessful party. But cost allocation is provided for in almost all arbitration rules, and it should be exercised. Parties should know from the outset that's what's going to happen. And that, of course, focuses parties' minds on the risk profile, the changes of the case, and it, particularly in perhaps more modest value cases, legal costs can be of significance compared to the value. So those three innovations, I think, are important and pervasive.
Sam, in fact, whatever you mentioned and whatever we discussed right now with respect to the procedure, efficiency, and innovation, all of this would require a lot of analysis from the expert and analysis of the evidence, etc. How do you see the role of experts evolving in this, especially with respect to delay experts? And I remember we had like a long discussion in September, on this, and that was quite a very vivid discussion, but something for our viewers that, how do you see the role of experts evolving with respect to the quantum experts, the technical experts, and are tribunals becoming more skeptical of expert advocacy? Do you also see that somewhere as an arbitrator?
Well, we certainly have different traditions in what we expect of experts around the world. So in the US have a more tradition, United States have more of a tradition of partisanship in expert evidence. In the UK, and I think in India, there's much more of a tradition of the expert owing their primary duty to the court or the tribunal. But there are trends in the way in which experts are dealt with, and it is very interesting. So we have the development of the professional expert witness. So you now have, particularly when it comes to delay analysis and quantum, we tend to have experts these days who are full-time experts. That is good in one sense because they know what a tribunal wants to know about. They know what their duties, what they're expected to address in relation to the arbitration and the dispute. But there's a challenge to the precept of no financial dependency because they are in many ways therefore wedded to the dispute, wedded to perhaps the party instructing them. So there's that challenge, the balance between those two things. Secondly, you've got the complexity and profusion of information in construction and engineering cases. So experts are used almost as a proxy by a tribunal in relation to delay and to some extent quantum, where instead of looking into the detail of the cases, the tribunal might well rely upon the experts to almost determine those points of fact themselves, which creates its own challenges and problems, because some aspects are truly expertise, other aspects are fact-finding. Thirdly, there's a tendency, and this is certainly a feature in the English courts as well as in arbitration, to bring forward and expand the role of experts. That too encourages a closeness between a party and its case and the expert. So whenever there's an allegation of professional negligence, say there's a claim against an engineer or an architect, you would expect to have the supporting evidence of an appropriately qualified expert. Instead, you probably wouldn't even begin the arbitration or the claim in those without that. But it does tie the expert to the case, which poses its challenge. I think there's a degree of confusion as to what's permitted procedurally, as between the expert, the lawyers, and in particular the clients. How close should they be during this process? Obviously, you want your expert to be as informed as possible, but plainly, if they're spending too long and in an untransparent way with the client and client representatives, that poses its own challenges as to bias and so on. And fifthly, perhaps associated with this, is the question of privilege in relation to expert documents. Different jurisdictions have different approaches to, for example, whether or not a draft expert report is disclosable. In parts of Australia, for example, there is a requirement to disclose literally everything that an expert produces, whereas that's not the case typically in arbitration or in some other jurisdictions. So you've really got some quite complex and challenging issues, which does indeed cause tribunals to become somewhat more skeptical of experts, and perhaps that they are advocating the case. But at the same time, given the nature of our cases, it's impossible to do cases without experts. We rely on them, we need them, and a good expert can really make and help a case and help a tribunal.
That's very interesting, and I also agree with you, because it also somehow leads to segregation of duties and also specialization of expertise, that somebody who's good at doing this job. And so I absolutely concur with your views on this. Let's move to a little bit of the technological aspect of construction arbitration. I would want to, there's so much of debate about, AI and the future of construction arbitration. How is actually technology changing the nature of evidence in construction arbitration?
Yeah. There's a number of ways in which it can help greatly. Plainly, in terms of the discovery or disclosure phase, it's very helpful. And the tools that are now available, allowing the legal team to refine and present and prepare the corpus of documents is very useful, and sort of the searching processes and so on. So far as presentation of evidence is concerned, there's increasingly PowerPoints and other presentations are used. I think one should approach that with some care. And certainly I do not see one of the challenges associated with delay expert evidence at the moment is that there's a skepticism on the part of tribunals that what's presented is an output from a computer without knowing what's going on inside the black box. And I think there's a risk that could continue further, especially, and it leads to cross-examination where, say, if I'm cross-examining such evidence, I dig out 5 or 6 documents which show that part of what the output of that program has come up with is factually wrong, and then it gets you nowhere. So I think in terms of the final presentation of evidence, I think the use of technology and AI is less useful and less to be trusted.
But Sam, how do you see that the parties and the tribunals, especially, are dealing with AI-related cybersecurity risk and confidentiality in an environment where we are relying so much on digital evidences?
Yeah. Well, I mean, it's an absolute rule, and indeed, it's one of the reasons for arbitration that it is confidential. So everything that's in that box of what goes on in the arbitration must be sealed off from everything else. So you certainly won't have, or you shouldn't have, say, the final hearing documents being uploaded to a large language model or some such, to unless there are clear barriers put in place. So I think the challenges posed by the development of the tech are greater, but I don't think the principled approach to confidentiality has changed.
Thank you so much, Sam. Sam, now I would want to proceed to the other half of our podcast, where a lot of our viewers would be, practitioners from India, young lawyers from India, and your 2 cents will be so very helpful to so many of young lawyers like us. As a leading construction silk in London, what in your view makes advocacy in construction arbitration unique?
Yeah, sure. I think, and it's the bit I most enjoy, one real feature of construction arbitration is expertise, is the use of experts, whether they're technical, delay, or quantum. I can't think of a single arbitration in construction where I've not had experts. And so one of the unique features, I think, is developing the ability to cross-examine those experts. I'm a history graduate. I didn't study construction, or I'm not an architect or anything like that. But you develop the skills over time to master for the time being, often with the help of your own expert in the same discipline, to understand the particular issues being raised and where or not the other side's expert may be lacking. And of course, they start from a difficult starting point, which is unlike factual witnesses. They are paid to give evidence, which is something we talked about earlier. So that I think there's always scope for careful cross-examination. Of course, a tribunal doesn't want just an ad hominem attack on the individual, nor generally about their CV, but it needs to be tied into the technical or delay or quantum issues that are an issue in the case. But when you bring those points together, you can then try to elicit what your side's case theory is from that expert. And I find that the most interesting aspect of construction arbitration as an advocate.
What advice in general would you like to give, to the lawyers in India who are especially entering in this field, those who do not have a technical background or an engineering background especially, and who wants to make their mark in construction arbitration?
Yeah.
Because I remember...
Yeah. Well, look,
please go ahead.
In India, you've got some leading law firms. And leading senior advocates. I'm not going to name any individuals. It's invidious. But there is a developing there's a developing group of practitioners, both on what I would call the solicitor side and on the advocate side, but across the piece, who have experience and skills in construction arbitration, both domestic and international. And it's a case of really perhaps seeking some initial employment with those individuals to build up that skill base. Of course, there are other ways of developing it. The Society of Construction Law India is, I know, I think in 2 weeks' time, in December 2025, having their 5th annual conference. A colleague of mine in my chambers, Ratan KC, is the chairman of that society, and that is very much a developing society with good things happening. Another leading practitioner, 𝗵𝗶𝘀𝘀𝗀 SA, has founded, along with many colleagues, the Arbitration Bar of India. It's an exciting, and they may well have, I know that they do run courses, and so there are many opportunities to develop those skills. Of course, you can also now, I think across the world, there are a number of educational institutions that do an academic legal course in construction law. So, for example, University of London, King's College does a master's in construction law, and I'm certain it may be that your own institution, Nidhi, the Ambani, does some specialist courses. So that's another way of developing your knowledge and understanding.
Indeed, Sam, what you pointed out, that are some of the, most common areas where many individual lawyers have been working. And especially, I would like also a lot of a segment of our lawyers are going to be somebody, like me, who've cross-qualified and trying to work in, different jurisdictions across the world. I want to hear your views, because you interact on a daily basis with lawyers in London who've cross-qualified and are from India. What are the challenges do you see being faced, especially by the Indian lawyers who cross-qualify in other jurisdictions, and especially and also connecting this with the debate on bringing in foreign lawyers in India, including also, thirdly, the need to have a corpus of judges who are familiar with arbitration in the Indian sector?
Okay, there's quite a lot in what you are saying there, Nidhi. I think it's more associated with policy rather than, and that's what I was involved in very much when I was chairman of the Bar of England and Wales last year. I had a lot of liaison with the Bar Council of India and with a whole host of other senior practitioners, retired judges, and others on this interesting topic. India is has a growing economy. It's such a successful a country, and with that, you have Indian clients, Indian MNCs that are looking to employ specialist construction practitioners and want specialist construction tribunals. So that's the internal pressure for development. I think the government also has wisely suggested that they want India to become a hub of international commercial and construction arbitration. I think that's a laudable aim and something to be encouraged. And so as part of that process, I think it has to become international in nature. And so a host of those points that you raise, whether it's the Indian institutions on arbitration, which are growing, whether it's the review of the rules of arbitration, which has happened in Mumbai and Delhi in the IAC. Those are all positive steps forwards. I think there's two areas that still need work in order for India to follow, if you like, what happened with Hong Kong many years ago, as what's happened with Singapore more recently. It needs to allow international personnel to participate. And that will then, if you like, grow the pie, as it were, and there can be work, co-counselling between English silks and others, Indian senior advocates, but also junior solicitors who are working for these already excellent Indian law firms, but perhaps co-counselling with, say, an English silk. And I think that would attract more arbitrations, more international construction arbitrations to be seated in India. The second challenge, of course, which is really outside my remit, but it's one that's obvious, is the enforcement of arbitration awards and the challenges associated with that. I know that, for example, leading Indian practitioners have talked about this, as well as others, such as in Bar and Bench relatively recently, Lord Peter Goldsmith, and indeed former Chief Justice 𝗕𝗫𝘀𝘀 is on the record on these topics. There's some good steps forward in the Delhi High Court, for example, on the specialism of the judiciary. But I think procedurally, the courts need to support arbitration, and that means probably not interfering in awards. It means enforcing them quickly and efficiently. Now, those two aspects put the international into international arbitration seated in India, and enforcement. Those two things would, if you get those cracked, I think the future is extremely bright for international arbitration seated in India, and younger practitioners would have everything to look forward to, because nowhere in the world has there been an example of liberalization of practicing rules, for example, around arbitration, where the arbitration market has reduced. It's always resulted in success. London many years ago, Hong Kong, Singapore, now I would say Dubai, and Saudi Arabia is heading down that path. So India has that opportunity, but you need to, if you like, give a bit to get a lot in terms of the practicing rules.
That's very futuristic, and you've very broken down it very well, and very visionary, I would say, the way you've put that statement across. If there is one thing that you would like to predict, Sam, in a major shift in a construction arbitration in the next decade, what would it be?
It's a difficult question. I think there's a lot of misconceptions about construction arbitration. For example, that it's all about counting bags of nails. It's much more interesting than that. There's a lot of law involved. There's a lot of, yes, factual complexity, but it's a really great area of law and a great area of work to study in. So if there's a misconception, that would be it. So far as developing construction arbitration is concerned and making it more efficient, I think we have to grab the potential that AI and tech developments offer in the way in which we manage the documentation, because that is a real heavy weight. But there's no substitute, ultimately, for a week or 2 week final hearing at which the tribunal hears from the key players in a construction dispute as to why we've ended up where we've ended up. And I think that, I hope, will always be protected and can't be substituted by an AI decision maker. So that would be, that's an area of development, I think.
Thank you so much, Mr. Townend, for such an insightful and engaging conversation. In today's segment, we've covered a huge amount of information, from the realities of modern construction disputes to the evolving role of experts, the rise of technology and AI, what truly makes advocacy in this field unique, which you dissected it and explained it very well. What really comes through is that, construction arbitration is changing very fast, and so are the skills and mindsets to navigate in this sector. Your perspective on the young lawyers, how they can build confidence even without an engineering background, will resonate strongly with many in our audience who will be watching this podcast. To everyone listening, thank you so much for joining us. I hope today's discussion has demystified some of the complexities of construction arbitration and sparked new curiosity among a lot of young lawyers about where the field is exactly going. Thank you so much, Mr. Townend, once again for joining in. We'll be back. We'll be back soon with another conversation. Until then, take care. And thanks so much, everybody, for tuning in. Thank you so much.